Right, well, good morning, everybody. Today is October 26th, 2020. These conversations are now being recorded by Lease. Opportunity to kind of check in and see how things are progressing, and to check in anytime to see what's really going on and how they change over time. So for those of you who don't know, my name is Patrick MacQueen. I'm a real estate attorney here in Arizona. I've been doing this for 16 very long years. We handle all sorts of litigation, all sorts of transactional matters, both on the commercial and on the residential side. Before getting into the leasing updates that I want to make sure everybody has, I do want to give a couple of quick updates as to kind of the trends that we're seeing in my office. First big trend is that the commercial real estate world is still in a little bit of a world of hurt. We're still in this sort of rough patch. We see a lot of restaurants, we see a lot of gyms, we see a lot of spas, even now retail and office who are struggling. And so landlords and tenants are getting into some pretty heavy lease amendments. We're seeing some tenants asking for lease buyouts, and so or tenants have the opportunity to buy out the remaining lease because they can't operate in the same fashion that they were. So it's somewhat of a sad situation. We also now have, though, something that's very, very positive for tenants, and it's one or two rulings from the court that basically say, hey, landlords, commercial landlords, you should have been doing more for these tenants during the pandemic, during March, April, May. And so we now have some courts who are admonishing landlords for not having done more for these tenants. And so we see now, and that was in the restaurant concept or context. So if anybody wants a copy of that ruling, I'd be happy to send it to you, because it's very, very important. The court is basically saying, look, landlords, you put these folks into bankruptcy, and now they've got no other option here but to remain in this bankruptcy. And so you, landlord, are going to be penalized for that. Okay. And that has largely emboldened some tenants. So some tenants are coming back and saying, well, hey, you should have done more. And now I'm going to take my situation to the court and see what should have been done. Okay. So now we've seen some tenants who are sort of saying, hey, we deserve more back in March through May. And now we have these court rulings that sort of support that. The best chance to get some of your rent money back, or the best chance to negotiate a deal, is to continue on your rent checks. If I haven't said this already, or if you haven't heard me say this before, this is key. Put on your rent payments, put on your rent checks that the payment is being made under protest, or that the payment is being made under duress. You have an opportunity to go back to your landlord and say, hey, look, I never should have had to make these payments in the first place. And now I want some of my rent money back. I should have only had to pay a percentage of the rent. And so if you put that stuff on your rent checks, if you're a tenant, you have a better shot at getting some of that money back. So I have memos, I have court rulings, whatever you need, shoot me an email at the end of this, and I'll get you whatever it is that you need that might support your particular situation. Second big issue, and this may affect some of your clients, some of your own rental properties, is that the residential eviction matters are continuing. Okay. So the first issue is commercial leasing. Now we're talking about residential leasing, because I know that some of you have clients who have large portfolios of rental properties. And so now what we're dealing with are new rules, new court rules that require references to loans. They require time limitations on eviction hearings. And so there are new procedures that everybody has to follow in order to comply with these new court rules. We also have substantive eviction laws that have changed as well. Okay, we still have Governor Ducey's executive orders in effect. One of which expires in 5 days. It expires October 31st on Halloween. It expires, and that one was providing some relief for tenants, but that's going away. We still have the CDC moratorium, and the CDC moratorium came into effect in September. And that basically says, look, if you're a tenant, if you're a residential tenant who is likely to be homeless as a result of an eviction, then you can get your eviction postponed until the end of this year, until December 31st, 2020. Okay. So we have Governor Ducey's Act that expires. We have the CDC Act that is still out there, but it doesn't apply to a large scale of people. And then we had the CARES Act moratorium. And largely the moratorium, this was this federal moratorium that says you can't evict somebody if you have a federally insured mortgage loan. That's gone away. And so the only obligation you have now under the CARES Act is to provide a 30-day notice to these tenants before you're able to evict them. We have updated charts. We have updated sort of checklists. If you are a landlord and you need one of these charts, you can now sort of plug in your situation and determine what kind of notice and what kind of procedures you have to follow. I'm happy to give you those after the class. If you shoot me an email, I'll get you whatever you need on those. So consider that as being sort of big update number 2. So big update number 1, commercial leasing world, still in a tough spot. Residential evictions still kind of flying off the shelf, and I think they're going to continue for at least through the end of this year. Another trend, and this is the one that I wanted to talk about today. Another trend or another issue is that tenants are running into some problems when they vacate their leased premises. So we're talking about commercial tenants and whether they're leaving through a formal lease amendment or lease termination, or whether they're doing a midnight run, which we've seen a lot of lately with some of these restaurants that are just taking all of their stuff and all of their equipment and getting out of there, or whether they're just leaving, right? They've either got their lease expires or they've negotiated a termination date. We're seeing a lot of issues that are creeping up because tenants are improperly either terminating their leases improperly, or they're leaving and they're leaving some boxes unchecked. Okay, and let me get into this. And so what they're doing is they're creating, they're not reading the leases, and they're creating the potential for a lot more liability on them. So we created this checklist. If you need a copy of the checklist, let me know. This checklist was actually published in Arizona Business Magazine because they found it to be somewhat helpful. But the first issue that tenants need to consider is signage. So oftentimes, in an office or retail world, the leases commonly require the removal by the tenant of signage, and that the tenant pay for that stuff. Well, guess what? If they're leaving early, if they want to get the heck out of there, they're not even considering that. Then they get a big bill from their landlord that says, hey, I had to remove your signage at my cost, at my contractor's cost, and here's the bill. And by the way, you're not getting your security deposit back because I had to take down all of your signage. So, you want to take a look at the lease to determine what it says for signage. If you're intending to leave, if your client is intending to leave, first step, look at signage. Second step, look at the security deposit. Review the lease to determine under what circumstances the tenant is going to be recovering their security deposit. Address it with the landlord if at all possible. So if you're amending or if you're terminating the lease based on a negotiated buyout, which is again very common right now, we're seeing these lease buyouts. Address the security deposit in that buyout agreement. And if you're just leaving and you expect to get a security deposit back or a portion of it back, ask your commercial landlord for a pre-termination walkthrough. Okay, so make sure you've read the lease to determine what portion of the security deposit is getting returned to you, and then ask your landlord for a walkthrough so that your landlord is sort of bound by what they find. Okay. Third thing to look for are alterations. The tenant, if at all possible, should be confirming that they don't need to restore the premises back to its original build out, that the improvements or the alterations may remain in there. Because guess what? If the landlord has to come in and wipe out and take out all of your alterations or all of your improvements, they're going to send you a big bill for having to do that. So first step, take a look at the signage. Second step, look at the security deposit. Third step, determine what alterations were made and try to get some sort of confirmation that those alterations can remain and that the landlord isn't going to charge for those alterations or improvements or the removal of those alterations and improvements. Okay. Fourth thing to look for. Okay. And this applies whether you're leaving on time, whether you're leaving late, whether there was economic issues or not. Always look to the holdover provisions, because if you start staying later than what your lease termination date provides, guess what? You may have to pay holdover rent. Holdover rent in most commercial leases is between 150 and 200% of your existing rent. And so people are getting nailed on, they're staying too long, they're not making the determination as to whether they want to continue in the lease. And so they're getting nailed and having to pay holdover rent. So those 4 or so provisions are key. I would say there's probably 7 or 8 things you really need to hone in on. And if you need a checklist to address each and every one of those things, just shoot me an email. But those 4 are probably the things that we're seeing tenants kind of goofing up on the most. Okay, another issue that we're running into, those were tips for vacating properties, okay? I also want to talk about situations where tenants and landlords agree to continue on in a lease or to amend their lease, and where a tenant is actually staying. And so these are things that a landlord should consider whenever there's a lease amendment, okay? Whether it's economic based or whether it's just, hey, we're expanding the premises and we need a lease amendment, or we're renewing the lease and we need an amendment to document this renewal. It's a great time to clean up your existing leases. So if you have an amendment, if the tenant is proposing an amendment and you're a landlord, you can say, well, sure, I'm happy to enter into this lease amendment with you, but we need to use this time to sort of clean up some of the other issues that we found and in connection with the existing lease. So there's about 4 or 5 different things. Again, I have a memo on this if you need it. I have an actual checklist if you need it. Feel free to shoot me an email after this. I'll provide my contact information. But number 1, the first thing that should be completed or cleaned up is making sure that everything is up to date. Up to datedness is sort of the first issue. That's not a real word, but you want to make sure everything is up to date. Number 1, are addresses up to date? Notice addresses, okay? So in most commercial leases, there's a notice provision, and the notice provision says, here's the address that official notice gets delivered to. Well, a lot of times that's wrong. Over 5-10 year leases, sometimes the notice address changes. You want to make sure that's up to date. How about this? CAM reconciliations. You want to make sure those are up to date. Everybody knows exactly where CAM reconciliations stand. What about insurance? Okay. A lot of times landlords let this go and they don't even check on insurance on a yearly basis or quarterly basis to make sure that their tenants are up to date on the insurance. Well, guess what? Let's make sure, if we're going to do a lease amendment, that at the same time, this tenant is up to date on their insurance obligations, okay? Making sure that we're named in a proper fashion according to the lease if we're a landlord, okay? So first issue is up to datedness. Again, that's not a real word, but let's make sure everything is up to date in terms of notices, in terms of addresses, in terms of insurance, in terms of CAM, okay? Second big issue is, should we address our force majeure clause, right? The pandemic has taught us that, hey, these may be events of force majeure, or a pandemic may be an event of force majeure, or it may not be. So let's update, let's clarify what it means to have an event of force majeure. Tenants want broad force majeure language, obviously, and they want broad rights as it pertains to force majeure, and that's okay. But landlords should largely be okay with defining the scope of force majeure. But landlords always want and always insist on, no matter what, that rent be paid, okay? So if we're gonna broadly define an event of force majeure, great. But if I'm a landlord, irrespective of whether you can close for a while, whether you can limit your operations, whether you can operate from 9 a.m. till 3 p.m. instead of 7 a.m. till 6 p.m., if you wanna limit yourself, that's fine, but guess what? You're not limiting the amount you pay me, okay? So that's a huge one. So yes, it's okay to broaden the force majeure scope, but landlords are not okay with saying, hey, you don't have to pay rent. Okay, so that's a key one. So first is up to datedness. Second is whether you want to address your force majeure clause. Third, let's make sure we have the right parties. Sometimes, people assume leases. There are subleases. Let's make sure that the tenants are properly defined as the tenants, that it's the same tenant that originally signed a lease, or if there's a new tenant involved because there was a lease assignment or a corporate reorganization, that the person signing on behalf of the tenant or the person signing the lease guarantee is the same person, or there is authority for that new person to sign the documents. Okay, so a lot of times we'll get these leases And it's like, well, who are even these parties? You're telling me that you're a tenant and you have authority to sign, but you're not the same person as that original tenant. So let's make sure that all of the original guarantors are referenced. Let's make sure that this new person signing the document has the authority to sign the document. And if we need them to confirm their authority, well, then we can get authority documents. We can get the new LLC operating agreement. We can get a corporate affirmation from the corporate headquarters that these are the appropriate people signing. Okay, so we want to make sure the parties are correct. All right. The fourth big thing that we're doing when we clean up these existing leases is that we're getting an affirmation from the tenant that they understand that they have continuing obligations under the lease, and that the landlord has no continuing liability or has no liability for anything that they've missed, or CAM reconciliations, or that they owe the tenant anything. So again, we want an affirmation of continuing liability and a statement of non-liability that there is nothing owed by the landlord to the tenant. Okay, so these are 4 or so of the 5 to 6 things that actually we want to make sure are in a lease amendment. Okay, so again, we've seen a lot of people goofing up on improperly terminating their lease. They take off too early, or they take off and they forget to check things. And then when we're actually negotiating a lease amendment, we want to make sure that we're cleaning up the leases to the greatest extent possible. If anybody needs a checklist as to what to look for in either of those situations, or wants a copy of that ruling that I was talking about, or that landlord tenant chart, feel free to shoot me an email. My email address is on there. My phone number is on there. Give me a shout. We'll get you all that information, and you guys will be ready to go and help out your commercial tenants and landlords. So again, today is October 26th. We want to date stamp this stuff because this stuff changes, and we've seen trends, that have been quite interesting, and now we're in the kind of a glut of lease amendments, and so this is a great time to clean those up. I'll open it up to questions. If anybody on the call right now has any questions, I'll stop my share, and happy to give you some free legal advice. Well, you get what you pay for, but happy to give you some free legal advice if anybody needs it. All right, well, speak now or forever hold your peace. Well, thank you guys so much. Again, this is October 26th, and this is the law as we see it as of today. So I'll turn it back over, and we'll be done.
All right, thank you so much, Patrick. And if you can do me a favor, because I did make you the host, just to stop recording for me.
You got it. Let's stop the recording.
Awesome.
Did that stop it?
I don't know. Let me see if this.
Yes. Here.